Hello and welcome to Surveyor Says, the podcast from the National Society of Professional Surveyors. Each week, we bring you fascinating guests that are involved in the profession of surveying. We cover a lot of ground, including Table A Talk with Gary Kent, Point of Order with the NSPS Joint Government Affairs Team, Future Focus, highlighting current and future leaders of the profession, and everything survey-related in between. Thanks for joining us here on the podcast, and hope you enjoyed listening to this episode of Surveyor Says. Hello and welcome to another episode of Surveyor Says. This is the continuing saga of Table A Talk. My name is Tim Burch, and I have the pleasure of sitting across the video camera from Mr. Gary Kent, the outgoing chair of the ALTA NSPS Land Title Survey Standards Committee. Like I said, we're not going to let him get away too far. We've still got to be able to pick his brain when we can. So one thing that's come up in conversation is, we talked about these standards being an ever-changing standard, living, breathing document. However, the question is, and I think everybody has seen this that's been dealing with land title surveys, Gary, that every survey we see that says that it's land title survey, everybody's different. Now, granted, Platts a survey, everybody's got their own styles and things, but this is a very detailed standard. And so I guess I'm asking from your perspective, from the committee's perspective, some of the things that should show up on this survey besides what's, obviously it's listed out here, but when we're talking about title issues, when we're talking about Table A things, what stands out as some of the things that really need to be depicted on this survey to make sure that the client is getting what they're asking for? I guess Table A is a good place to start.
All right. Yeah. It's a pleasure to be back with you, Tim. And it's a really good question and something for us to think about. Surveyors tend to be a lot of black and white, and surveyors also don't like much to be questioned about things. They don't like it when somebody calls and says, hey, I don't understand this or whatever. We can kind of get defensive. But I think there's a couple, before I specifically answer the question, a couple things that I think are very important. We're doing this survey ultimately so that the title company has the information they need to remove the standard survey exception off of the survey. And the standard survey exception basically, to put it in terms that are, I guess, as clear as I can, the standard title policy, title companies are responsible for what's in the public record, and they're not responsible for stuff that could be observed on the property that might be a burden or an encumbrance on the title, right? So if there's an easement in the public record, they're responsible for that, right? They're going to say, hey, there's an easement, and everybody knows about it. But if there's no easement and yet there's a row of utility poles cutting across the property, no electric line easement, but a row of utility poles, they don't have responsibility for that because nobody knows that's there,
right?
Unless it shows up on our survey. I shouldn't say nobody knows it's there. I mean, that gets a little more complicated than that. But they are not responsible for stuff that's out on the ground unless they have a survey that shows it. So our job out there is to, number one, reflect the stuff that's in the records that shows up in the title commitment, but also to be the eyes of all of these parties. Because, nowadays, what goes on? Let's say it's some office building we're doing a land title survey on. It's owned by a hedge fund in San Francisco, and the buyer is an insurance company in Atlanta, and the title insurance is being written out of Chicago, and the seller's attorney is in Seattle, and the buyer's attorney is in Nashville, right? And none of those people are ever going to see this property, and so we are their eyes, right? When I do a full-blown land title survey program, I spend about an hour talking about title insurance and, really what is going on here so that we understand. And I think it's very important that surveyors have an understanding. That's what we're doing out here. And so we want to be as helpful and as thorough as possible within the context of the standards to help people, read the survey and understand what they're seeing so that they can look at it and say, aha, look at that row of utility poles, and I don't see an easement. We better write an exception for that. It's not up to the surveyor to necessarily point this stuff out. A lot of lenders say, make us a table of encroachments. Well, I don't like doing a table of encroachments because that's not my job. My job is to show that row of utility poles, not tell them that that's a problem. But there's obviously a fine line there. But I think the important thing is that we understand ultimately what we're doing. Now we know that the buyer's attorney is going to look at the survey, and the lender is going to look at it very closely because obviously they don't want to loan the money if they see something that puts their money at risk. But I think a lot of people have the idea this is just kind of a glorified boundary survey. No, it's not. It has a very definitive purpose, and so with that in mind, then we can let's look at Table A and talk about what can we do, what are we doing on each item, and how can we present the information so it is most helpful. Now. I mentioned in our last session, if I recall, about the fact that the wording of any Table A item can actually be negotiated, and I think that's an important point here. The exact way that it is addressed, so we keep that in mind. But Table A item 1 is monuments. Okay, well, monuments are in some states they are not optional. In some states, they are optional. If you are in my state of Indiana, Table A item 1 always gets checked off because we have to either set or find a monument or a witness on a boundary survey in Indiana. And land title surveys are a type of boundary survey. They're not just a glorified boundary survey. They're a boundary survey to a very specific set of standards.
Right.
But a boundary survey nonetheless, and so in Indiana, unlike a lot of states who require monuments unless the client doesn't want to pay for them, we don't have that option in Indiana, right? You either set it or set it, find it, or set or find a witness, or you are in violation of the law.
Good.
So that's not an option. But a negotiable thing, if people read it, it says monuments placed at all major corners of the boundary of the property. And I get people say, what's a major corner? Well, that's probably in the eye of the beholder. If it's a rectangular piece of property, there's 4 major corners. If it's if it's a property with 33 corners, they're probably not all major. And I think that's probably up to the surveyor to decide what that is. But somebody might say, but I want all of them set. It's an option in my state, but I want all of them done. Okay, well, that's fine. How do you deal with that? Well, you would have a legend that shows a symbol, and it would say what that symbol indicates, a monument found or set or whatever. Addresses, I think the address is probably best dealt with maybe 2 different ways. One of them is if you have a structure on the property, you have a residence or a building, within the confines of that building on the drawing, you put the address right along with what it is. 4-story brick office building, and then 140 North Pennsylvania Avenue, Carmel, Indiana, or whatever. I believe on our title block at Schneider, the address of the property is actually in the title block also. We have the address of the property there. That's probably not a huge big deal, but it's something, I think along the lines of what we're talking about here, Tim. It's like, well, if they check the item off, if they want to know the address, let me make it easy for them to see where the address is, right? They shouldn't have to pick through the entire document to see where that is.
And it also I'll be honest with you, it also clarifies what is in title versus what is observed. We've had instances where the property we've surveyed may be 925 West Main, but it just in the title it might say something else, 919 or whatever. It's clarifying that what we are surveying is in fact what we're talking about in title as well. So it's a quick check, but it's nonetheless it's another check.
Yeah, and of course, anybody who's done surveys for title in the residential world know that happens, or it used to happen, not that unusual, where they would send you an address and you'd be at that address, and it's like, oh, wait a minute, that's not the right property. Or even, probably one with addresses that is a little more, takes a little more thought, is like an apartment complex where there may be 108 addresses on that property. And how do you deal with that? And I know we would deal with it by showing an address on each building. But,
exactly.
Item 3 is on the flood zone. Well, we in Indiana we have to write a surveyor's report, and we put the flood zone as one of the items in the surveyor's report. But I think that is most logically dealt with a note that says flood note, or flood zone note, or something to that effect. That's fairly well delineated, so people can know where that note is. And it's normally, and I'll apologize for my grandfather clock going off in the background if anybody hears that. Exactly what you put in your note is probably a business decision. We have definitive wording that we use that includes a statement about map scale uncertainty, because of course we've all been in a situation where we're taking a 1 inch equals 1,000 foot flood map, and we're blowing it up to 1 inch equals 30 feet. And then we're very precisely drawing that flood line on there, which of course is a joke.
Right.
But flood note, I think most people do that. The land area, same thing. I think what we would normally do is somewhere on the property we have the identifying information, who the owner is, what the deed record and page are, and maybe the address, and then that's probably where we would put the area right there. And but somebody might want to have a separate note. There are people who believe, and I don't agree or disagree with this. I guess I would say I'm kind of ambivalent about it. Every table A item that's checked off, there ought to be a note to that effect, and that's probably actually not a bad idea. So if they checked off item 1, you would say monuments set or found are indicated in the legend. And they check off item 2, you would say 140 North Pennsylvania Street, Carmel, Indiana. And item 3, you would put your flood note there. Item 4, you would put the area there. And then you would have then maybe item 5, and you would simply say contours are shown, and the datum is this, and the benchmark was that. So I kind of like that idea. I've never actually done it, but it's probably not a bad idea to think about. They checked off 7 table A items. Well, let me just have a little section of my survey that lists those 7 items, and with a statement about how it was addressed on the survey. Item 6 is an example of that, right? Item 6A is when we are going to list the zoning classification, setback requirements, height, floor space area restrictions, and parking requirement. So I'm going to have some sort of note, and this would be a place where maybe having that list of items. Oh, here's item 6A. What did you do about that? Well, here's the zoning information I have, right? So you could maybe have a section of your survey that says table A notes, and then list them like that. On 6A, I think it's very important that surveyors be very careful with this. Lenders often want surveyors to tell them whether there are any violations of the zoning. And my response to that is whether something is a violation is a legal determination, right? The maximum height allowed is 35 feet and the building is 40 feet. Is that a violation? I don't know. What I'm going to tell you is the building's 40 feet, right? And somebody else is going to have to decide if that's a violation. But in particular on this item, parking seems to be the one that's probably most common, where the lender wants you to say, are there enough parking spaces?
Right.
Right. Well, I'm just not going to go there. And I am also not going to interpret the zoning ordinance if it says, if they say, well, how many parking spaces are required? My answer is going to be in the context of the ordinance. So if the ordinance says at a restaurant you need one space for every employee and one space for each table in the restaurant, right?
Right.
Well, I'm not going to ask them how many people work there, and I'm not going to ask them how many tables there are. I'm going to say how many parking spaces are required, one for each employee and one for each table, right? And if they say, well, is that enough? I'm going to be, I don't know. That's your problem.
Yes, not my determination.
So, not my determination. Yeah. 6B, it kind of speaks to itself, but that's where we're going to depict the setback lines. And so if you had a set of notes on 6B, you would say the setback lines pursuant to the zoning report provided are shown hereon, or something to that effect. Item 7, exterior dimensions of buildings, the square footage, the measured height. Again, you could just have a note that says that responds to each of those items. 7A, exterior dimensions of buildings at ground level are indicated, something to that effect. Item 8 is an interesting one. We actually, Richard Bales, who is a wonderful attorney, spent most of his career with Chicago Title, and now he's with another title company up in the Chicago area. But he and I talked about Table A, Item 8, several years back, and said, we ought to just make this mandatory. I mean, for gosh sakes, everybody does it, right? We all show the sidewalks and the flagpole and the parking bumpers and the side, the landscaped areas. We all do that. Everybody does that. And so we ought to just, and if you didn't, the client's going to say, hey, you didn't finish the survey, right? So we said we ought to just make that mandatory. But that immediately led to the realization that if we do that, we would have to define what is a substantial feature.
Right.
And I'm going to respectfully decline to start that list of things. So we quickly decided, no, that has to stay as optional, because then it's kind of up to each of us to decide what's something that needs to be shown. Item 9, the number and type of parking spaces. Under the new standards, being of clearly identifiable parking spaces on surface lots, what are they wanting to see? We're gonna draw the stripes. Well, this is where Google Earth or getting a drone photography or something to that effect becomes really, really helpful. You're still going to have to count them, but that one kind of is. And in my note, I'm just going to say, the striping on surface lots is shown, and we counted 762 spaces, of which 4 are motorcycle and 3 are electric or whatever.
Right. And we should, I want to clarify there as well that, and I'm hoping you'll agree with me here, that nowhere in there does that identify and basically, I won't say certified, that we have we've measured those stalls and that they are all in conformance with the standard stall for whatever that municipality may be, whether it's 8.5, 9 foot wide, depth, whatever. That has nothing to do with the measurement. Those are just physical spaces that are shown on the property. Yeah,
that's a very important point, because you will get lenders who try to coerce you into, into certifying or saying something to the effect that, yeah, these are these are all compliant with the zoning. I'm not going to measure all of those. If they want me to, I will. That's going to cost them a boatload of money, and that's
Right.
going to be an extra. I remember in particular a shopping center. We've done a survey on it probably a dozen times over the last 35 years. And at one point it was being sold, and they wanted a parking count, and we did. And they asked us to check, and we checked, and it was still that number. And they said, well, but that's, how the lender's attorney can be, well, that's not enough spaces. And I'm like, well, I don't know what you expect me to do about it,
Right.
And what ended up happening was they said, well, today's Friday. We want you to go back out on Monday and count them again. Like, okay, well, whatever. Well, over the weekend, they paid somebody to go out there with a paintbrush and some white paint and just painted some parking spaces behind the building, right?
Oh,
well, they weren't even, remotely compliant or anything, but there they were, and so we're like, okay, there's 7 new spaces. Now we can say.
exactly.
But yeah, you have to be very careful what lenders want you to put. They used to want you to certify to it, and I think we've mostly gotten away from that. But they want notes now, and they want to note that the parking is compliant or that there's no violations of this or that. You have to think very carefully before you just respond kind of blindly to some of these requests. Can you actually say what they're wanting you to say?
Mm-hmm. Exactly.
Item 10, and people will note that there used to be a 10A and a 10B, which was 10A was the determination of the relationship of party walls, and 10B was plumbness of certain walls. And the whole plumbness thing has been a wacky thing, and I'm sure you've run into it, Tim. They'll check that off, and they're supposed to say to us, we're concerned about the south face of that building, but they don't, right? They just check it off,
do.
and they don't even recognize probably what they're saying. Excuse me. And they're like, well, I don't know, we just need that. Well, they don't need it. So what we did is we got rid of 10B. If somebody's concerned about the plumbness of a wall, then they can negotiate that on table item 20 and say, hey, we're concerned that wall might be leaning. And of course, if it's a substantial lean, we probably should be showing it, if it's close to a boundary line anyway. But so on item 10, this is a determination of the relationship and location of certain party division or party walls. And I would hasten to add actually that a party wall is a legal construct, right? A party wall is technically a legal agreement between two properties as to a common wall. Now, I don't know that that's, ALTA obviously knows that, but it's a little unusual, at least in my world, to actually see a party wall agreement. Gosh, we do land title surveys in downtown areas all the time, buildings that are abutted up against each other, but we don't see party wall agreements that much. But that's why the item also says division wall. So in which case we're just talking about the physical relationship. And a suggestion, by the way, in that regard, particularly in a downtown area, would be to go up on the roof, because otherwise, if it's a downtown area, all you are able to see is perhaps the seam between the windows or between the buildings at street level, right?
Right.
And there may be a 1-foot gap between those two buildings, and they decided to just brick over it. And you're not going to know what you're looking at unless you were get access to go up on the roof and look at it. Now, I'm not saying that you have to do that, but it might not be a bad idea to request access to get up and kind of see what things look like.
Exactly. We've run across that in Chicago here. That has exactly happened. We've had places where there have been basically gaps in between buildings that you could not determine from the front or back of the properties. That's a great point. Thanks for making that one.
Yeah, that was actually a suggestion made by a friend of mine. We did a session here in Indianapolis last summer. A number of us have just a lot of information in our heads about surveying in the Indianapolis area, and we said, you know what, we ought to get this out there and share what we know about certain areas of the city and certain tricks of the trades, and that suggestion came up at that point. On table AM11, the utilities. This one, what would need to be helpful and placed on the face of the survey, in this case, is probably more clear now than it perhaps was before. But one thing I would do, and I have mentioned before about the note that follows Table A, Item 11. It says note to the client, insurer, and lender, and it has information on there about how we're going to try to locate the utilities, but if it's not excavated, the information is going to be not complete, all that kind of stuff. I would take that note and put it on the face of the survey.
Absolutely.
I said I would put it in my contract, and I'd put it on the face of the survey.
Mm-hmm.
Because people check this item off and they think they're going to get accurate, complete, and reliable information, and every surveyor knows that unless they excavate the entire site, that just is not happening.
Right.
So we want to do what we can to control, to manage their expectations there. And that's probably the most important thing you could do on item 11. Now, on 11A, the choice is that we would rely on plans or reports provided by the client. Okay, well, if they check that off, then I'm going to have a note that says, here's the plans that they provided. I'm going to say who provided them, on what date, and I'm going to identify the documents that were provided so that I'm protecting myself.
Perfect.
And then 11B is the markings, on a private utility locate request. So we would talk about that sort of thing. One of the things that we have done at our company is if we got a hold of plans, and I don't know that this is still going on, it should be, and I would suggest it to everyone. We used to create our own little utility report, and it would have a cover, then we'd say, we made an 811 locate request, here's the number, here's who responded, here's what we heard, here's what we found, and we got plans. And we would actually copy the plans and put them in this report, so the client had 100% of the same information that we had. And I kind of still like that idea. Item 12. This is government agency survey related requirements. It might be a HUD survey. It might be Fannie Mae. Might be a wind farm lease on BLM land. We would want to make sure people understood that there were other requirements that were involved here, and so we could put a note like that on there. Item 13, names of adjoining owners. We just kind of delineate where those adjoining owners are, maybe where the dividing line is, to the best of our ability, and then we just put the name of the adjoining owner with their deed record information. And by the way, we have a requirement now that those adjoiners that include a tax parcel number.
Right. That's good.
Item 14, distance to the nearest intersecting street. This is one I think that it's such a simple requirement. What it's got, 10 words, 11 words in there. But what is it they're looking for? Is this related to being able to get a driveway permit? Is it, what is this about? And are they interested in how far it is to the center line of the adjoining street, or not the adjoining street, but the nearest street, or to the right-of-way line, in which case I may have to do some survey work 800 feet away to determine with some level of precision where this is. I suspect most of us, it's like, well, I go to Google Earth and it's 840 feet down to the center line, and so we maybe just put a dimension 800 plus or minus 840 feet to the center line of 22nd Street. But again, if you formatted a series of Table A notes, then you could put that information right there, and and I think that would actually not be a bad way to do that. Item 15 is an important one, and this is the one where someone might decide to use, maybe they say, yeah, I don't need to do all of this stuff on the ground. We can, we can show the buildings based on some rectified ortho photography that we have. I'm like, okay, well, but we need to talk about this because you're going to see the roof line, not the building. And there's going to be shadows, and you're not going to see all the utility features that you might have seen on the ground. But if everybody's fine with it, I mean, if the lender and the title company and the client and the buyer are all fine with it, then who am I to argue? And I can invoke this item, but the requirement here is discuss the ramifications ahead of time, including the precision and completeness, and then have a note on the face of the survey. So on item 15, the note would be, certain information came from this source on this date, and the expected precision is this, and blah, blah, blah. So I think item 15 is an important note. If you go that way on the survey, there's some important information that needs to be on there.
Is that something that we've noticed in the Chicago area? Some of the surveys that we've had to do in the last couple of years, turning golf courses into industrial parks. And when you're doing an ALTA survey over a golf course, and you've got restroom facilities and various things that are out in the middle of nowhere, and cart paths and things. Yeah, I think this is ripe for, and we use aerial photography for this. But like you said, it has to be negotiated, and it has to be explained in the note that this was the expectation. This was the tolerances we used. Did it save a lot of time? Absolutely. Was it, were we showing a restroom facility in the middle of a golf course within a reasonable tolerance? Absolutely. Versus running a traverse out there to shoot something underneath a tree. So yeah, I agree. That's a very important that we need to make sure that we document that very well.
Yeah. Again, control, managing their expectations.
Exactly.
16 and 17 were HUD items, and those are probably good ones for notes also. Evidence of recent earth moving work, building construction, building additions. Sometimes surveyors will say to me, well, what is recent? I'm like, well, put yourself in my shoes. I can't define what recent is. Oh, that's 3 months. Okay, well, if it's 3 months and 1 day, then I don't have to worry about it, right? Well, what I tell surveyors is if it looks recent, whatever that means, or if you're concerned about it, then put a note on it. It's not going to hurt anything. Right. Looks like there was a building addition put on the building in the last year, or whatever. But I think this would be a really good example of a note that you could put on your table A notes with regard to item 16. Did not. Now, these types of notes you'd be careful about too, because you don't want to say there is no evidence of this, right? That's not the statement you want. What no. The statement you want is we did not observe any evidence of.
Exactly. Right? Nice.
That can be a true statement. Somebody might complain and say, well, you should have observed it. And then you might have a normal standard of care question. But if you say something wasn't there, that's a different statement than saying that you didn't observe something there.
Right.
Item 17 is one that's a little bit different, and this would cause us to have to contact jurisdiction and say, in a city of any size, they probably have some sort of thoroughfare plan. I know Indianapolis does, and it's online. So if I'm surveying on 71st Street, I can go to the thoroughfare plan, and it says, well, the plan is that 71st Street's going to be 120 feet wide with 4 lanes sometime. Then I just put a note on that says, the thoroughfare plan says this. It causes me to have to do a little research, and the note becomes, I think, fairly obvious. the thoroughfare plan online at this link says this, or I talked to Street Commissioner Tim Burch and on Monday, January 11th, and he told me this. Right.
Right.
Item 18, we reworded item 18 a little bit, trying to make it clear, and I don't know that we hit the target or not, but what item 18 is suggesting is that if there's an offsite easement on, and this would typically be an easement that's listed in Schedule A of the title commitment, where you'd have the fee parcel, it's this 5-acre parcel, but then there's this 50-foot wide access easement that goes out the back and goes out to, Meadowbrook Avenue. The title company will insure that easement also, and so typically these would be insured easements. And what we're trying to get to explain with Table A item 18 is that they check that item off. I'm going to treat that easement like a fee parcel. So everything that applies to the rest of that I would do on the fee parcel, I'm going to do on that easement, right? Show the evidence of this and that. And the only thing we're not going to do is monument it. And so, with regard to that item, I think the important thing there, by the way, is to have a conversation with the client. If you are surveying a fast food restaurant out in front of a mall, there's probably cross parking and cross access easements over the entire mall, which means your fee just went from $8,500 to $85,000 because you have to survey the whole mall. And I'm fairly certain that's not what they had in mind, right? So you want to look at that, and along those same lines, if they want you to do that item, but you don't have a title commitment yet, you better qualify your proposal, because it may turn out there's 5 offsite easements and you didn't have any money in there for that.
Yes, exactly.
So, what you would do with item 18, if you had your set of notes, is you would say, what I would do is list the offsite easement. Well, this 50-foot access easement and this sanitary lateral easement are shown here on, something to that effect, and were included as part of the survey. And that gets us to the last item, 19, which is, it's not related to title insurance, but we realized a number of years ago that there was a major disconnect, that virtually all attorneys thought that all surveyors carried professional liability insurance. I gave a number of programs where the attorneys were shocked when I said that they don't. And so NSPS and ALTA decided, that's a pretty big problem if people don't realize that, and maybe we should give them the option to require that. So that's the history of this. Now, what was happening prior to 2016 is that lenders were doing things like telling Tim, you need to list the extent of your E&O coverage on the face of your survey. Right. I got $2 million worth of coverage. I don't know who wants to put that on their survey, because that would just seem like an invitation. And I swear I would have told the attorney, well, send me a letter with the extent of your coverage, by the way. I want to know that.
Exactly.
Yeah. So we actually, in 2016, we talked with ALTA about this, and I had said, what, I would like to say that this item need not be addressed on the face of the plat or map. And one of the ALTA attorneys said, it sounds to me like what you ought to say is this item shall not be addressed on the face of the plat or map. And there's that word shall, by the way, but we left that in there that way. And so that if that item gets checked off, as a surveyor, you need to respond to it, right? Provide them an email that says, I have this much coverage, or a copy of a certificate of insurance.
Right.
But other than that, you do not have to have anything on the face of the survey. You don't even have to list item 19 as one of the Table A items. Right? I mean, for gosh sakes, if they have a certificate of insurance, what more do they need?
Exactly.
So
exactly.
So, and then of course, if you had an item 20, you'd want to have a pretty specific note about that. So I think those are those are kind of the considerations and what people are looking for and the things we ought to be thinking about when it comes to the Table A items and how we react to them. And again, I'll go back where I started on this kind of long answer was, I want to be helpful. I want title companies, and they do in Indianapolis. Title companies in Indianapolis have told me any number of times, like, "Oh, we saw it was a Schneider survey, so we knew we'd be fine."
Right.
That's the kind of reputation you want, so that you want to be helpful, you want to be knowledgeable, you want to understand what's important to them, so that you are their surveyor of choice, and when they need expertise, they contact you. And I think that's such an important thing for us.
Exactly. Well, that's one thing I always stress to not just staff here, but contemporaries. This is a national standard that just because the locale you're working in, your normal standard of care may not address, especially, a rural-based surveyor look at this and go, well, number 10, I mean, party walls, that means nothing to me. Well, it does to somebody somewhere. So don't just discount a lot of these things because it doesn't fall into your purview. This is a national standard, and make sure that whatever is applicable to your standard of care and your area, make sure that it's addressed and provide the best possible service and information to your client, bottom line. So, no, I appreciate you going over these, because I think there's always some confusion on how should we explain what we did. And I like how you've ran through them, and hopefully our listeners do as well.
Yeah, let's hope so.
Yeah, exactly. All right. Well, that'll wrap it up for this episode. And once again, we appreciate Gary sharing his wealth of information on everything ALTA, NSPS land title survey standards. We will be back to bug you again, Gary, sometime in the very, very near future, because, like you said, this is a living, breathing document, and who better to ask the questions than Mr. Gary Kent. So,
I appreciate it, and I'll look forward to it, Tim.
All right. Well, that's it for us. We'll wrap it up here. We'll talk to everybody again. See you very soon. Thank you. You've been listening to the Surveyor Says podcast, brought to you by the National Society of Professional Surveyors. If you have any questions about today's episode or any other topic, please email us at info@nsps.us.com, and we are here to help. Visit our website, nsps.us.com, to learn more about our association, the programs we administer and support, our sustaining members, and information about future episodes of Surveyor Says. Subscribe to the podcast on iTunes, Apple Podcasts, Google Play, iHeartRadio, Spotify, as well as our podcast host, Podbean. And remember, it's a great day to be a surveyor.